Good afternoon. The Memphis and Shelby County Board of Adjustment is hereby called to order for its regularly scheduled meeting of May 27th, 2026. My name is Tim Rainey, and I'm chairman of the board. Mr. Jeffrey Penzis serves as secretary of the board. Mr. Penzis, may I get a roll call, please?
Mr. Bruce.
Present.
Mr. Campbell.
Present.
Mr. Claybrook.
Here.
Vice Chair Savage Selden.
Present.
And Chair Rainey.
Here.
We have a quorum.
All right, thank you. The Memphis and Shelby County Board of Adjustment is the oldest appointed governmental body in Memphis and Shelby County. We were established in 1925. The board hears appeals of the administration of the zoning ordinance, requests for variances from the zoning ordinance, and other requests articulated by local zoning laws and adopted pursuant to the enabling legislation. The 8 members of the board are appointed, 4 by the mayor of Memphis and 4 by the mayor of Shelby County, with confirmation by the Memphis City Council or Shelby County Board of Commissioners. We serve without remuneration. At this time, I'd like to swear in the staff. You remain seated. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you. Make it a motion to approve the minutes from last month's meeting.
So moved.
Second.
Is there any comments or questions on those? No. Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion passes. Mr. Secretary, please provide us a secretary's report if there is one this month, then explain the procedure for this meeting. I think we do have a secretary's report this month.
Yes, sir, Mr. Chairman. I'll introduce Director Ragsdale.
Thank you, Mr. Penzis. Mr. Chairman, members of the board, I think most of you know that I took the director position for DPD in January, and since then, I've also been the acting zoning administrator until that position was filled, and I'm happy to announce that your secretary, Mr. Jeffrey Penzis, has now been selected as the zoning administrator. So,
Congratulations.
Very excited about that. So he will be now making the interpretations that you are acting on. And I would also like to announce that Mr. Lucas Skinner has moved into a deputy administrator position as well. So two great announcements, and we're happy to have them move up and continue their leadership in the division. So thank you.
Perfect. Thank you so much. Mr. Secretary, if you'll give us an explanation for today's procedure.
The procedure for this meeting will be as follows. I will introduce each case as listed on the agenda. Copies of the agenda can be found on the front podium. For each case, the planner with the Division of Planning and Development will give a presentation. At the conclusion of the staff presentation, the applicant will have 5 minutes to present his or her case. After the applicant's presentation, those speakers in support will have a total of 5 minutes, and those speakers in opposition will have a total of 10 minutes, and then finally the applicant will have 2 minutes to provide rebuttal. These times do not include time for questions from and answers to members of the board. The chairman may provide additional time provided both sides are given an equal amount of additional time. All parties who wish to provide testimony to the board will be sworn in by the chairman. If a member of the audience wishes to provide testimony in support of or in opposition to a particular case on today's agenda, he or she will need to fill out a speaker's card for the record. Speaker's cards are available at the front podium. Once filled out, speaker's cards can be submitted to any DPD staff member at the left podium. We do not need speaker's cards from the applicants since their names are already part of the record. After all parties have been heard, the board will close the public hearing, make a motion, and then deliberate on the case. If the applicant or any speaker would like to be heard after the conclusion of the public hearing, or if a board member wishes to hear additional testimony from any party, a 2/3 vote is required to reopen the public hearing pursuant to the board's rules of procedure. Please note that once the public hearing is reopened, both the applicant and opposition will be allowed to provide additional testimony and/or rebuttal. All motions by this board will be made in the affirmative. The private acts governing the board require the affirmative vote of at least 5 members to approve an application regardless of the number of board members present. The board may also vote to hold an application for a period not to exceed 3 months with the consent of the applicant or 1 month without the consent of the applicant. All section numbers that we refer to come from the Memphis and Shelby Unified Development Code, or the UDC, which was adopted by the Memphis City Council and Shelby County Board of Commissioners in August of 2010 and became effective on January 1st, 2011. I will introduce the entire UDC and make it part of today's record, thus dispensing with the reading of individual sections. The board is vested on the power to act on these cases before us today under the provisions of Chapter 9.22 of the UDC. Mr. Chairman, I submit that all cases have been filed in proper order, all applicants have been notified of this hearing, and all notice requirements have been fulfilled as required by the UDC.
Thank you, Mr. Secretary. At this point, the board will establish a consent agenda. To establish the consent agenda, the secretary will call out each eligible case. If any member of the audience, staff, or board member objects to a case being placed on the consent agenda, he or she should do so by a show of hands when the secretary reads the case. Once the consent agenda is established, the board will vote on all cases placed on the consent agenda as a whole and will not hold individual public hearings as to those cases. Mr. Secretary, which items on our agenda are eligible to be placed on the consent agenda this year, for this month?
Item number 6, BOA 2026-28 at 3852 Macon Road as a hold for 1 month. Item number 7, BOA 2026-31 at 2465 Millbrook Avenue as approval with conditions. Item number 9, BOA 2026-34 at 9161 Wilder Ridge Lane as a hold for 1 month. And that is it.
Okay, thank you very much. May I have a motion to approve the consent agenda as established by the secretary, which is 6 as a hold, 7 approval is conditioned by staff, and 9 as a hold.
So moved. Second.
All right. I'd like to remind the board that by voting on the consent agenda, he or she affirms that he or she has read the staff report and is in full agreement with the conditions. Mr. Secretary, may I get a roll call, please? Oh, and let the record show Mr. Love and Ms. Scurlock have joined us.
Mr. Bruce,
Yes.
Mr. Campbell,
Yes.
Mr. Claybrook,
Yes.
Ms. Conrad, Mr. Love,
Yes.
Ms. Scurlock, Chair or Vice Chair Savage Sheldon.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
Yes.
Motion carries.
All right, thank you very much. So if you're here for items 6 or 9, you've been held as requested, and then 7, it was approved in accordance with the staff opinion. Mr. Secretary, if you could call our first case or cases we're going to hear today.
Item number 1, BOA 2025-148 at 5380 Benjystown Road. And item number 2, BOA 2025-149 at 5350 Benjystown Road.
Okay, thank you very much. Mr. Britton, good to see you again. These cases,
Good afternoon.
They look to be very similar. Do you want to try to handle them together?
That would be fine.
Okay, just wanted to make sure. Okay. All right, thank you very much. We're going to get a staff report on those, and then we'll let you come up and speak with us.
Thank you.
Okay, thank you. All right, if we could get a staff report on these 2 cases, please.
Okay. I'm True Sabuosi with DPD. I'll be presenting BOA 2025-0148 and BOA 2025-1049. And the request is a use variance from section 2.5.2 to allow a group shelter. It's located in the county, and the pink section that is recorded is BOA 2025-148, and the orange highlight is BOA 2025-149. It's zoned as R8, residential single family 8 zoning, and we sent out notices. And okay, so this is the site plan. The applicant's request is classified as a social service institution. So though it's grouped as a group shelter, what the operation is seen as a supportive living facility. Now, a supportive living facility is a permitted use at the residence. However, the applicant doesn't meet the requirements because they want to operate it as a commercial use. So if this was a non-profit, it would be a by right use. They wouldn't need a variance. Now, because of that, it's a permitted use. Variances are not, they cannot meet this. They cannot meet paragraph 9.2.6b because it's a permitted use. And also, a variance should not be granted because a person wants to operate it purposely for business. and that's why they are here. So we are recommending a rejection because there's no hardship. They cannot request a variance because they want to use it for a profit. And we are recommending a rejection with the following conditions. Thank you.
Okay. Are there any questions for staff? All right. Mr. Britnum, if you'll come up and...
Good afternoon, Mr. Chairman, board members. My name is Dedrick Britnum. I'm a lawyer here in Memphis. My address is 3385 Airways Boulevard, Suite 229, 38116 zip code. I have with me today Ms. Helena Copeland. She's the statewide development director for her company, Support Solutions, and Support Solutions is the applicant. Just for what's going to happen this afternoon, Ms. Copeland is going to go through part of the slide deck, and I'm going to finish with the last part of the slide deck. For the record, however, we want to make sure that the board understands and staff understands that the request has always been for a supportive living facility, and you saw the definition of supportive living facility earlier. Staff showed you on the screen. So with that said, I'll turn it over to Ms. Copeland, and she'll go through the first part of the slide deck. Thank you.
Okay, Ms. Copeland, if you'll give your name and address for the record, and I'll swear you in.
Sure. Helena Copeland. My address is 2979 Crossbuck Drive, Bartlett, Tennessee.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and share with us.
Sure. So again, I'm Helena Copeland. I'm from Support Solutions. If you know anything about Support Solutions, we've been around for about 20 years. We provide services for individuals with intellectual disabilities as well as co-occurring mental health diagnoses. We support individuals in the city of Memphis and also throughout the state, ages 13 and up. And so today we're here to talk about our supported living for our specialized enhanced supportive housing. So our mission at Support Solutions is that we do not give up on anyone. The individuals that we'll be supporting at the two properties that are here for the Board of Adjustment hearing support individuals that have been to anywhere between 10 to 15 to 20 placements prior to coming to us. Nobody in the States wants to support them. We currently have a 90% success rate at what we do. The homes per se, they are in the county. And we only support about 4 individuals per location. Some of our accomplishment with Support Solutions, we are a Carver accredited agency. We do get the highest accreditation every year, which is a 3-year recognition. And we are also a preferred provider for all 3 MCOs through TennCare, which is Blue Cross Blue Shield, United Healthcare, and WellPoint. Some of our SSMS is what we call ourselves, so people may know us as Support Solutions or SSMS, and the 4 tokens that we utilize by identifying our acronyms is safety, support, momentum, and success. And these are the principles that we like to instill into the residents that we support. Our mental health housing expanded services in 2019. It was established with just 2 locations in Bartlett, Tennessee and New Bern, Tennessee. We now have 9 total locations with the hopes of continuing our expansion throughout the state. We do have 7 of those 9 locations here in the city of Memphis. The members will be served at Benjastown Road. It would be approximately 4 residents. We do have about 2 to 3 staff per home, per shift. And this is a transitional placement. So the members that are supported there, they're only here for about 90 days or longer, depending on their level of care and what their treatment looks like. When they have successfully completed treatment, they will transition into long-term supports. And I do primarily place these members in the city of Memphis. And this is Mr. Britnum's part. Thank you.
Thank you, Mr. Chairman. I have one more handout I'd like to pass up, please.
Yes, sir.
All right. This is a picture of the zoning map that was shown earlier by staff. This particular site is the one that has the R-8 zoning label right in the middle of it. As you can see, it's an oddly configured corner lot. with the curving third side, and it also intersects with Benjistown Road and Benjistown Road and North Circle Road. And I want to make a point about that, please. And the handout that you have will emphasize the point. Usually when these cases come before the governmental body, there's an issue about the traffic going into the suburbs. As you can see, when you come out of the site, you turn right to make your way to Benjistown Road, then you turn left onto Benjistown Road, and then right again onto Robertson Road, and that takes you to North Watkins. There's no possibility of any traffic going through these subdivisions that are to the east and to the south. Next slide, please. Now, these are the approval points that we set out for the board. It does have a hardship, the uniqueness of the lot itself. The properties are uniquely configured and well-suited for individuals with intellectual disabilities and enhanced supportive housing. Developing the site for standard R8 residential use presents physical and economic hardships due to the as-built specific campus needs. And by the way, these two facilities were built in 1989, and they've been there since 1989. They were operated by a previous company, Open Arms, but they were operated there for some 17 or 18 years. The next point is the low-impact operation. The public need and necessity highlights that these projects serves a highly valuable demographic. The next one is the variance would not be contrary to the public interest. The facilities provide specialized care that keeps individuals integrated within the community rather than institutionalized. The variance will not be contrary to the public interest. Special conditions exist. The specific layout of the Benjistown Road properties makes strict compliance with the R8 residential zoning unnecessarily restrictive. The literal enforcement creates unnecessary hardships, and granting the variance will not cause substantial detriment. The low turnover, highly supervised nature of Support Solutions model ensures no negative impact on adjacent neighbors. The next slide, please. And this is the development timeline. As I said earlier, it was built the two facilities were built in 1989. And also, this is one parcel according to the assessor's office that has two lots. And those lots are each 3.49 acres, so they're very large lots. The assessor's class is commercial. The assessor land use is dormitory, and it has two structures. From the period 2003 to 2024, numerous permits were applied for and issued on a commercial basis, as well as some residential permits. As I said earlier, Open Arms Care Corporation occupied these two facilities previously. Now, the taxes paid to Shelby County trustee are in the commercial category, and for 2028, that amount was $6,338.78. Next slide, please. Now, this is from the assessor, Shelby County Assessor's policy. Property appraisal and assessment are based on use. When nonprofit use, owner applies for exemption. When approved, the assessment goes to zero. Therefore, no property tax revenue to Shelby County from the subject property. So if this property was turned over to a nonprofit for operation, they could apply for an exemption, and then the Shelby County would get zero property taxes. However, since 1989, the owners have paid commercial assessment property taxes since first construction in 1989 and they were paying it as nonprofit use. Next slide, please. And this is the economic impact. Direct support professionals, those are the people that will be on the site. They have program managers, nursing staff and medication, support personnel, transportation staff, and administrative compliance personnel. These two facilities, as built, they will accommodate up to 8 individuals each. However, the client is willing to limit the number of individuals cared for to 4 each for each property. That would be a total of 8 instead of a total of 16. So that would be a condition if you decide to approve this, should you decide to approve this application. And the last slide that I gave, that's a handout, if you'll take a look at that, please. It shows that Benjystown Road is a minor collector and Robertson Road is a major collector. And then the blue is a minor arterial, which is North Watkins. So the traffic route would be as presented on this particular last slide that I gave you. If you have any questions, I'd be happy to answer for you.
I have a couple questions. First, I want to ask, I know that we've dealt with this before, as far as like, if this was a nonprofit, it would be allowed by right. When they did our code, was there anything specific said on why we care for these things if it's a nonprofit versus a for-profit? Or is it just something we help nonprofits do, kind of like how we allow churches in neighborhoods, but we don't let businesses in neighborhoods?
Mr. Chairman, Robert Roll, Wayne County Attorney's Office. Besides being in the UDC, that provision is also in state law.
Okay.
Same provision.
Okay. And Mr. Britton, you can answer that question too if you know anything about it. But then
Yes.
I assume there's a reason why. I mean, this is already a going business, and just deciding to become a nonprofit is not the easiest thing to do. So if you could speak to that a little bit.
Yes, sir. And I do agree with the Assistant County Attorney on this. It is also state law. That particular section of the Tennessee Code says that local zoning regulations cannot regulate nonprofit support living facilities. And yet number 4 says in that statute exactly what it says here in the UDC. Now, the history behind it is that, as I talked about earlier, the reason that they don't want nonprofits, the reason they don't want commercial activity operating these facilities is because of traffic, is because of noise, and because of other standards that the city can still regulate those standards. However, as we demonstrated this afternoon, traffic would not be an issue because it's unlikely that any traffic associated with these facilities would go through those 2 subdivisions. And noise, there are only 4 occupants or 4 persons per each facility, and they're on large acres. 4.39 acres each. So they're well situated away from the subdivisions. And lastly, it was operated by a nonprofit for 17 or 18 years without any issue as to noise, traffic, and other types of standards that local regulations would govern.
Can I ask a question? Yeah. And I might be missing something. Where in the UDC does it differentiate that supportive living facilities are all considered nonprofit? Is that
Yes.
Is that
I believe it's on page 13 of the staff report. Is that?
It's right here on the screen too. It's the second last sentence, which reads, "This definition does not apply to a residence where a mentally retarded, mentally handicapped, or physically handicapped persons reside when such residents are operated on a commercial basis." So essentially, you have to be a nonprofit.
This is the section we're asking for a variance.
Well, you can't get a variance to the definitions, which is why we have it as a use variance for a group shelter.
Okay. That makes sense. Any other questions? questions?
I have a
Yeah,
question.
Ms. Gerlach.
Yes. I mean, I guess other than the obvious of profit, are you still able to operate as a nonprofit if it's not approved? Is there something preventing you from operating on a nonprofit basis?
This particular company has been in operation since 2005 as a for-profit company, and that's their business model. And they've been operating these type facilities since 2005. And Ms. Copeland has been with the company since 2020. No, she's been with them 20 years, I'm sorry. So, and here's the conundrum. These particular properties, they're already built. There's an investment out there, and they're built to be supportive living facilities. They're not suitable for any other type use. So and they have not been occupied for a period of time because other nonprofit facility operators were not interested in this particular site. So to keep this property on the tax rolls as commercial and bring it into compliance with the taxes that have been paid for many years, it would stay on the tax roll as commercial, and they would continue to pay property taxes under the commercial classification.
Quick question regarding the for-profit basis. Is that most of their proceeds are coming from insurance, or is it a private pay? How are they, what makes it the for-profit portion of that?
Most of our proceeds do come from insurance, from the MCO reimbursement, TennCare, and we do have some private pay services.
Question. Have you considered maybe having the property owned by a nonprofit that contracts with the for-profit entity?
Yes.
And why would that not work?
Well, I don't know the reason it won't work. It's just that it's outside their business model. And we realize that what the definition says. However, keep in mind, the reason that language is in there is to be able to regulate noise, traffic, and other standards. And this particular site, since it's been operating for so long, since 1989, and it was operated as a nonprofit. However, they didn't have any issues during that period of time. And this operator is as good or better than the previous operator. They just happen to be for profit.
Is there even a sign up there? Like, is there a sign on site for this?
No,
Okay.
we identify a person-centered base, and so we do not want our individuals to be identified, so people cannot ride by and say, oh, I know that's a care facility. We want them to feel as normal as possible when they're integrated into our services.
Yeah, because I'm very familiar with where this is, and I would have never known that those were care facilities there, like, because I've been there quite a bit. But so that's why I was wondering. So, okay. Any other questions? Okay. Thank you very much.
Thank you.
Yeah. All right, so if we could get a motion to approve BOA 2025-148 as conditioned by staff. So we're going to vote on them individually.
So moved. Second.
I think I would like to add the condition that no more than 4 residents will be allowed at any one time at the property. Is there any objection to adding that condition? No. Okay.
No.
Is there any general discussion?
I think the only other question, how long did they say people were going to stay there? Because a group shelter, as its basic definition in the UDC, allows like transients and things like that. So we may want to consider conditions related to that aspect.
That's correct, but individuals can stay a little bit longer just depending on what's going on with them, and then we identify long-term care placements for them. So when they leave us, they will either stay with Support Solutions or they will go into another provider, primarily, most of the time in Memphis. Some of them prefer to go to Middle or East, but that's very seldomly. So it can be a little bit longer, just depends on their treatment, how well they're responding, because they do have intensive applied behavior services, they have intensive individual therapy, individual management, as well as psychosocial rehabilitation group, which is a big word for adult life skills.
Sounds good. So you may just want to say no transient. Anything over 1 month is not a transient. So it sounds like.
Or is everybody typically staying at least a month?
Yes, we may
Okay, so
have
if we
one.
didn't- we're more worried about people every day coming
no.
in and out. And
Oh,
so
no.
so if we say no transient, that just means they always have to stay a month.
Yeah, that's no problem.
Okay. All right, so how would you put that in there, Mr. Sigrid? Like just no transient residents? Is that enough?
Yeah, something like that, like, no, how would you just word that? Residents may not be transients, or no transient housing is.
No transient housing allowed?
Yeah.
Okay. So is there any objection to that condition? I guess that would be condition 3, because we already had a condition 1.
Yeah.
So, okay. Without objection, we're gonna add that. Any other thoughts? Okay, I mean, it seems just the way these are built, they are group housing or a facility already as opposed to just a house. So that's why I find that unique about this. If no other thoughts, let's go ahead and vote on this one. If you'll give us a roll call vote, please.
Mr. Bruce,
Yes.
Mr. Campbell,
Yes.
Mr. Claybrook, Ms. Conrad,
Yes.
Mr. Love, Ms. Skurlock, Vice Chair Savage Selden,
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
and Chair Rainey.
Yes, I just want to, on the record, to put a couple things though. I know we have a lot of group shelter stuff. I do think this, besides it just being built that way, where it is located makes a big difference. Its location on Bengestown to Robertson, as Mr. Britnam said, not going through that neighborhood. Those neighborhoods are kind of dead ends. They shouldn't go through there, but like, that's why I think this one fits a little better to get a variance than maybe some others do. So, but I'm going to vote yes.
Motion carries.
Okay. And then what we're going to do now, let's get a motion to approve BOA 2025-149 as conditioned by staff with the same 2 and 3 that we added to the last case.
And I'll just say, and let the record show that the entire record for the previous public hearing, including all testimony, evidence, and discussion, is hereby made a part of the record for the current public hearing.
Thank you, sir. Is there any discussion on the second one? Okay, you'll give us a roll call, please, Jeffrey.
Did I cut you off before we had the motion and?
Oh, yes.
Second.
Thank you. Thank you.
Mr. Bruce,
Yes.
Mr. Campbell,
Yes.
Mr. Claybrook,
Yes.
Ms. Conrad, Mr. Love,
Yes.
Ms. Skurlock,
Yes.
Vice Chair Savage Selden,
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
and Chair Rainey.
Yes.
Motion carries.
All right, both approved. Thank you.
Schrader.
Absolutely, yeah.
Thank you.
All right, Mr. Secretary, if you could call our next case.
Item number 3, BOA 2026-20 at 2067 Linden Avenue.
Okay, I see the applicants here, opposition's also here. If we could get maybe a update from staff, if there is one, and then we'll move on to our testimony.
Okay. Good afternoon, Mahsan Ostadnia with DPD. The only update that we have is that the neighbor sent us a survey. This is a survey that was submitted to us by the neighbor in opposition for this case. And it appears that the grill structure encroaches to their property. And the applicant agreed on demolishing and relocating the grill to be on their property with a 0 feet setback.
Okay, thank you.
And the rest remains the same.
Okay. All right, the applicant will come forward. If you'll give your name and address for the record again for me, and I'll swear you back in.
My name is Josh Metcalf, and I'm at 2067 Linden Avenue.
Okay, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
Yeah, so things have changed since last time. What we're asking is to be able to take down our kitchen that we talked about last time and rebuild it just inside of the new fence line. We didn't know that we were encroaching. I have some slides in here and we'll talk about it. The fence line, we bought the house in 2016 and so did our neighbor. That fence line has always been our assumed property line. And that's what we were using when we built originally. And so since this has come to light, we're gonna fix it. The gazebo is still, in the southeast corner of the yard, 3 feet from the fence and 2 feet from the south fence. However, I also got a survey. It's actually over 5 feet from the east line, so it's actually no longer really breaking any rules. But that was by chance. I guess, how do I change the slides? Yeah, so just I guess a quick reminder of everything that we have in our backyard. Our gazebo's in the southeast, and there's some pictures so you guys can see. It's 3.5 feet from the east and 3 feet from the south. You guys can see our patio looking at the gazebo. That's kind of from the kitchen to the gazebo. Moving on. So since the last hearing, that picture was when our kitchen was being built. So I just want to be clear about that. That's what it looks like, almost finished. All that's left we have to put is the brick on it. We have gotten our permit for it, so the permit was approved, and we also applied for an electrical permit, and we had our electrician, the same one that put in our electricity for our swimming pool and our hot tub. Everything is up to code. It always has been. We just the pool we always did have a permit for, but not the kitchen, and now we do. I have talked to Cecilia in the office for permits and talked to her about if this variance will be approved. I just need to file an amendment to move it forward. And my plan will be to rebuild and get everything with proper permits up front. So I've learned my lesson. Moving forward. Here's the current setback and just showing that, some of our neighbors' concerns were the water, the drainage, and things like that. So you can see how it was and the fence was running along that line. Last time you guys were discussing, you were wondering if a fence could be put there. It absolutely could be. I had people, I actually had I had a contractor come out and give me a quote to do it. But it's gonna come forward now anyway, so that won't matter. We did remove the water. You guys can see we did that before the last hearing. These are the same pictures I gave you guys on paper last time. I removed the drain. I saw that they were concerned that I didn't conceal. It's just a hole. That's what it's not. It's just a hole in the back of the concrete. But there's no water going in or out. I do still have the water line running along the side of my house. I'll show it to you later. It's a flexible hose that I connected to my hose, and it's a hose bib and that's what it was originally as well. Yeah, thank you. There it is. So that's the hose. It was, like you can see, it was just, I went to Home Depot and bought a hose bib for $5 and connected it to that flexible hose. Our neighbors have never complained about water or about drainage or about anything up until bringing down the fence in February 27th. But like I said, now we have permits for everything. The drain is not an issue. And when I rebuild, I will definitely break into the concrete and connect to the sewer under the house. I've already talked to a plumber that will do that for me. So
you want to have you'll have like a working sink.
I want it because it's great when I grill. I like to rinse my hands off.
Yeah.
If we're gonna rebuild, I might as well do it correctly and up to code. I just want to be clear because I saw, some of the neighbors' complaints that are coming about the drainage and things like that. Our house, our whole street is on a slope, and we talked about that last time. Our yard is 17 inches higher than their yard, and our neighbor to the east is about the same higher than us. So everything washes down. We built retaining walls when we were putting in our patio and our swimming pool, but that height was always the same. That height was not affected because of anything we did with our building and our construction. I think some of the claims about us damaging their fence from drainage, washing my hands every 2 weeks is not doing that. That's it.
Okay.
I also want to be clear, I have been trying to work with them. I know last time I overheard you guys talking and you wanted us to come to a solution. I have had zero communication. I've tried my best to reach out to them, to their attorney, and they don't talk to me or tell me what they want or need. So we've been hit by code violation after code violation. And so I'm going to show you guys, I have screenshots of text messages that they never respond to, going actually all the way before the first variance and then afterwards as well. So I want to work with my neighbors on this, and so I'm not going to fight the survey. I want to just bring it down, move my kitchen forward, put up a fence, and be done. Moving on. So you can see there's me in the green. All of the green messages are from me to my neighbor with no response, and that was after the fence came down. I can't make anything happen if they don't answer me. So, and then the same thing with the emails with the lawyer. All he does is tell me to call him, and I've called him twice, and then I ask him for a solution, and he says I have to talk to my clients. So that's it. Yeah, and I that's the same story. So let's talk about the property line. I just want to be clear that it was completely unintentional. Obviously, I bought the house in 2016, and so did my neighbors. In January, we were both living there under the assumed property line of the fence. So I did hire my own surveyor, and it was off. So I'm not arguing that. But you can just see that, that aerial photo. That's the same property, I think, property line, but that's in 2006. And then you can see the listing from 2015 on their property. There's us in 2018 using the fence, and that was the same fence that was up that they just brought down. So it was not on purpose. Just so you guys can see the height difference that I was talking about. That's our yard is taller than theirs, which is why we built that retaining wall. And then we stopped there because there was a really big tree that was there that was actually, now that I think about it, was actually their tree. But I paid to bring it down. So that's why we stopped it there. All of that is actually on their property. So, if they want it down, it can come down. Just so you can see that is the picture of the far corner of my neighbor's yard. So they are actually gaining about 2 feet on the other side. We live in Idlewild. It's a historic neighborhood. Our house is over 100 years old. Everything has shifted. So that's it.
Okay, Okay, are there any questions? Oh, sorry.
No, I'm sorry. Yeah, I'll be fast. I know. I have a few possible solutions that I would like to propose. I think I would have liked to have done this sooner, but one, everything stays and the variance gets approved. Solution number two, I think, is the most ideal for everybody. We bring it down, we rebuild 5 feet from, or just inside of the new property line, and get a variance for the rebuild with everything up to code. I would ask, if my neighbors are willing to allow us maybe to angle our fence, so we don't have to move our pool pump, which is actually on their property as well. That's, I think, reasonable, but that's probably not a decision for this hearing. And so if not, that's fine. We'll move that as well. So that's solution number three. But I do want to know, I do need a fence. I've been messaging my neighbor and their lawyer, and it's because I have small children. They play basketball. Balls are flying in my neighbor's yard all the time. Now we're like, in trouble for my 10-year-old.
I need to cut you off, but you will get 2 minutes of rebuttal.
Okay. Yeah, sure.
Are there questions, though, from the board at this point?
I got a question. So if you if you rebuild your kitchen, which I guess is option number 2, that places you totally within your property line. Right?
Yes, sir. So the idea would be to move the property and build it just inside of the new the correct property line, so that we are 100% on our property, and then doing everything up to code. It'll be the exact same kitchen, just move forward about 2 feet.
I only asked that question because I know last time one of the concerns was the footings for a fence.
Oh yeah, so there will be plenty of footings.
Plenty of footings now.
Right, because we've already talked to our contractor. He's going to cut everything back down to the dirt, all the way along the property line.
Thank you.
Yes, sir.
Other questions? Okay, thank you. We'll be back. All right, if the opposition would like to come forward, I got you here, Brian.
Brian Nishimoto, 2061 Linden Avenue.
Hey, do you swear to tell the truth and nothing but the truth, so help you God?
I do.
Okay, and I have 2 cards here, another Nishimoto. All right,
Yeah.
do I need to split time anyway and let you know how long you've gone, or are you
I
good
think I can
just-
cover it.
Okay, good, just making sure.
Thank you.
Yeah.
Yeah, and I just want to address first, so it's funny how all the corrections were only addressed after discipline had been applied to this case. I think that's telling a little bit about the applicant's character. In addition to that, there were no differences in elevation. We have pictures to prove that. And then finally, our attorney has actually been speaking to him. He actually has not returned his calls from last week, and that is the applicant that has not returned the calls. So just want to cap that on the record. We can go ahead and start. So just to remind everyone, this vote concerns 2 variance requests: a gazebo and an outdoor kitchen that includes unapproved structures, utilities, and setback violations. The outdoor kitchen has also encroached upon my property, affects drainage, dumps into my property, requires trespass for maintenance, and previously raised structural safety concerns. This variance directly affects my ability to safely use and develop my property, long-term protection and safety of adjacent property owners, and whether code violations harming neighbors are held accountable. Next slide, please. As I present this evidence, I ask the board to consider 4 questions. Did code violations occur? Were they violations intentional or negligent? Do they negatively affect the neighboring properties? And is intervention necessary to ensure good faith compliance? If the answer to most of these questions is yes, we ask that the variance be rejected. Next slide, please. So did a violation occur at 2067 Linden? The evidence shows this was not an isolated mistake, but a pattern of violations, disregard, and negligent decisions. The applicant knowingly accepted the risk of building outside code requirements and should be held accountable. No different than receiving a speeding ticket for speeding. Let's review the violations. Next slide. The gazebo setback violation is acknowledged by the applicant himself in his submission. Yes, a clear code violation occurred. Next slide. Moving on to the outdoor kitchen, this is a recent property survey that shows the outdoor kitchen and pool deck encroach onto my property by more than 2 feet in most areas. This construction occurred without permission for encroachment. This was not the applicant's property to build on. Next slide, please. The outdoor kitchen crosses the property line, violates setback, and leaves inadequate access for maintenance from the applicant's side. And this is what he is proposing still in his adjustment. So yes, this is another clear violation. Next slide. For years, chemical-treated wastewater was discharged toward the street and property line. Photo evidence documents the installation and use of these drainage pipes on the property line. This was not neighborhood beautification. It was a code violation. Yes, a violation occurred. Next slide, please. Gray water drainage has repeatedly entered my property and continues to enter my property, leaving visible stains and water damage tied directly to the drainage location. Yes, a violation occurred. Next slide, please. The outdoor kitchen structure contains plumbing, drainage, and electrical utilities that were omitted from permit submissions and therefore not properly inspected, creating notable risk. The applicants recently submitted permits photos from its construction in 2020 and verbal under oath testimony here on April 29th did not accurately represent the structure's true condition. Yes, a violation occurred. Next slide. Do the violations appear intentional or negligent? These repeated issues demonstrate negligence. The applicant was heavily involved in the projects and made decisions that bypassed proper oversight and compliance. Let's review. Next slide, please. This is the incomplete permit for the applicant's full concrete construction from 2022. The applicant identifies himself as the contractor for this massive project, which covered most of his backyard in concrete, about 82%, and involved utilities increasing safety risk. Despite the scope of work, surveys, expert management, safety inspections, documentation, and proper safeguards were not obtained, and key project details were omitted or misrepresented entirely from incomplete permits. Next slide, please. This is the applicant's most recent permit for an inaccurately described privacy wall. In it, he describes the outdoor kitchen as a simple masonry privacy wall only. He omits the plumbing, electrical, drainage, and appliances incorporated into the structure that he mentioned earlier, underplaying the structure's impact. His own engineer later identified structural concerns requiring emergency reinforcement, requiring trespass into my property in order to address. These omissions misrepresented the true nature and risks of the structure, and the lack of proper inspection during the build allows these risks to remain unaddressed until they create major issue to my property, such as with the discovery of structural instability recently addressed. Next slide, please. Does the violation negatively affect the neighbors? Yes, the violations have significantly affected the neighbors, i.e. me, the adjacent neighbor. Let's review. Next slide, please. First, to clarify, I am the only directly adjacent resident seen in green and the only property owner experiencing the daily impacts of these structures from the applicant property in red. The structure, circled in red, in the satellite image to the right, sits in and next to my property only. Next slide, please. Let's talk about the terrible effects the applicant's structure has caused. From left to right, the impacts include fence damage from pressure and drainage of the structure, wastewater damaging my property, loss of ability to develop on my property, unabated and unsanitary gray water drainage and dumping into my property, increased flooding caused by extensive impermeable concrete coverage and runoff. And by the way, water from the sink is still gray water. Let's move on. The violations have also harmed privacy, security, and safety. On the left, elevated concrete structures impede my fence, worsen runoff, and create ongoing concerns regarding aggressive dogs accessing my property from the structures, like the outdoor kitchen, pictured third from the left. Foundational instability of multi-ton structures, pictured on the right. Electrical safety with uninspected and unpermitted lines installed, and fire risk from proximity of fuel and other combustible materials. The applicant's negligent construction also damaged property hygiene and curb appeal for years, with chemical wastewater dumping in front of my home, pictured second from the left, that was only addressed as a result of this process. Next slide, please. Because the structures are inaccessible from the applicant's property, workers regularly trespass onto my property for maintenance despite visible no trespassing signs, and often under the applicant's supervision, seen in the photograph. Intentional trespass. Next slide, please. So is intervention required to ensure the applicant acts in good faith? The board previously encouraged both parties to work together in good faith. Unfortunately, repeated violations, misrepresentations, victim blaming, and unwillingness to compromise have made good faith discussions impossible. Let's review. Next slide, please. Here are a few recent examples from left to right. Non-committal approach to address enforcement issues to curtail use cessation of his sink. Misrepresentations to this board regarding no plumbing at all at the site. Continued draining in spite of denials with no sealants applied to gray water source. Shifting blame to contractor for bad setback advice when the contractor is the applicant in the documentation. Next slide, please. Intentional misrepresentation of outdoor kitchen as a privacy wall in permits and in testimony. Intentional omission of critical safety facts about the structure, including electrical utilities, excluded under oath at the last board meeting. Continued trespass onto my property under the applicant's supervision. Next slide, please. The applicant has provided repeated threats to my workers, attorney, and myself regarding his intent to construct a fence on my property, despite the permit shown here filed by my contractor and the encroachment of his structures preventing my contractor from further developing my property. This was explained to the applicant on February 27th, the day the fence came down. We explained this to him in his front yard in front of the enforcement officer. Next slide, please. Finally, these lies in writing to gaslight, intimidate, and threaten to get his way. These are from the same text messages that the applicant showed, but he failed to show what exactly he had said. These repeated inconsistencies, misrepresentations, and omissions, threats and lies undermine confidence in the applicant's testimony and compliance. Next slide, please.
30 seconds.
What is the opposition asking for? Protection from illegal building and encroachment onto our property, stopping the criminal trespass onto our property, the ability to use and improve our property without interference, safe sanitary and private enjoyment of our yard, prevention of runoff, wastewater, and other safety hazards, and fix the violation the right way. If you're gonna fix it, fix it. Fix it within code. Don't substitute one violation for another. The only effective solution is removal of the non-compliant structures. Last slide. To conclude, did violations occur? Yes. Were they negligent or intentional? Yes. Do they negatively affect adjacent property? Yes. Is intervention necessary? Yes. For these reasons, we respectfully ask the board to reject the variance request and hold the applicant accountable for the consequences of these violations. I'll leave you with this question. Why should victims of a code violation have to shoulder or share the burden of their neighbor and perpetrators' indiscretions? Thank you.
Okay, hold on. Are there any questions for Mr. Moto?
I have a question.
Here, come on back up, please.
And thank you for all of that. That was very thorough. My only question is not what he's suggesting to do now gonna fix most of the issues you had a problem with?
No.
I mean, he's gonna take it off he's gonna remove it off your property he's gonna make room for your fence to be built. I think the runoff is just, I mean, he got 82%, non-permeable concrete. There's nothing you can do right now to fix that problem. So I think, so just a question, is what he's doing now gonna solve most of these issues?
I appreciate the question. So, no, the answer is it will not. The structure is still going to be on the property, which does not address one of the big issues, which is access for maintenance. He cannot maintenance the side that has all the items on it from his side safely, which basically puts the burden onto us. In addition to that, your question about the runoff, there is still drainage. Drainage is still coming. The land was the same level before, and we have pictures to prove that. We don't have them in this deck, but that is an untrue statement. Regarding the runoff, again, with 82% impermeable coverage, we are seeing a notable increase in flooding in our backyard that occurred at the exact same time as the item, or the structure being built. And regarding his statement that the other fence, that's not our fence. That's our neighbor's fence. That has nothing to do with our property. I'm not sure what that has to do with anything in this case.
Thank you.
Thank you.
Other questions for the opposition?
Well, let me ask about this. He suggested that there's been little communication with you, that you haven't been willing to communicate, or if you have, it hasn't been made it sound like it hasn't been in good faith. I just want to hear your side of that.
Yeah, I thank you for the question. So, yes, we actually have had communications with him. We did communicate this initially, as mentioned, when the fence came down on February 27th. I will admit this was it felt like a betrayal by a neighbor to find out that the reason why we were seeing such water damage on our fence, on our foundation, on our driveway, in our yard, was because of the applicant. We had no idea where the water was coming from. We assumed it was just ground seepage. We didn't know. But when the fence came down, we saw that there was pipes coming from a structure that we didn't know. And it was an extreme betrayal. Since that point, we sought legal advice. Our attorney has been speaking with the applicant. Obviously, this is a very emotional thing for us, so we exclude ourselves from these conversations and have allowed our attorney to have these conversations. The last conversation that we had that the attorney had with the applicant did not return the call. So it has not been on our end that we have stopped talking, and it has been at a great cost to us to have the attorney represent us in these conversations with the applicant. So that is, again, a misrepresentation by the applicant.
Thank you.
Thank you.
All right, so if the grill, whatever that structure is, gets moved off of your property line, there's also a question, I guess, about the pool pump. If those are moved onto his property, then you're good to put up your fence.
I'm sorry, I'm having a hard time hearing. I apologize.
So if the grill or whatever the concrete structure is that is in question right now, if that is moved off of your property line and with a proper setback, and then I'm assuming just by the presentation that you're not going to allow him to keep his pool pump on your property, if that is relocated legally, then you're good with everything else?
So let me rephrase that to make sure I understood it. And again, thank you for the question. If he's moving his outdoor kitchen within the appropriate code, 5 feet from the property line, so he can properly maintenance it, and he moves the pool pump onto his property, and he moves all the pipes, concrete, and everything else that's currently on my property, because the entire thing is one giant concrete structure, then yeah, I don't see why I would have any reason to contest that if he has it within the 5 feet so that he can maintenance it, and the pool pump and everything else that's underground has been removed from my property.
I think that's the whole reason we're here, right? If he did all those things, we wouldn't even be here today because he'd be within natural right to not even come to this.
Yes, sir, that is correct. That is correct. If he had done it the right way from the very beginning, we would not be having this conversation at all. None of us would be here.
But I think that's anybody who comes to these Board of Adjustment meetings, you know, is always for a variance for something that's not specifically allowed by right. So I guess
That's absolutely correct, and I agree with you. If you're seeking variance, it's because it's not within the code. But if you're troubling your neighbor as a result of that construction, who's right in that case? Do you split the baby in half? Is that what you do? Just because somebody's decided to do something outside of code? Or do you tell them that, hey, you were negligent in this case, hope you learn your lesson next time? Again, that's just my opinion. I see what you're saying, though. Thank you very much for that.
No, and then the last thing, you mentioned being able to service, he can only service it from your property. Is there anything specifically that's going to require servicing from the backside that we need to be aware of, just while we're kind of talking through it?
Yeah, I think almost everything's going to have to have service. I mean, the drainage pipes on the back, the electrical is going to be serviced from the back. I mean, to move the outdoor kitchen is going to require someone supporting it from the back. It's a multi-ton structure. It's masonry and concrete. So, I mean, I don't see how that would be possible without encroaching upon our property and trespassing. And we're not interested in, unfortunately, having him on the property. We just do not feel that it is appropriate. He has not shown, he's demonstrated dishonesty.
But it can be built differently with access on the front. It can. I mean, it does not have to have access from the back. There can be access panels that will allow him to access it from the front and not from behind.
And you're totally within your right to say you can't build it on my property, or you can't be on my property to build it, and that's for him to have to figure out how to make that happen and not encroach your property to lay block or, you know, paint it. You know, he's gonna have to figure how to do that out if that's a real concern.
I see what you're saying. I think part of the issue, though, is that we don't trust him to do the right thing. I think that's kind of the point here, is that we have seen throughout these slides and further evidence that it's not always the correct way that is approached. It's the most convenient way.
Okay. Other questions? All right. Thank you so much.
Thank you.
All right, so we're going to move back. We have 2 minutes for rebuttal. All right, go ahead.
Okay, so I want to address a few of those things. First off, the servicing the kitchen. Currently, there is no service required from the back. In the back, it is a solid structure cemented in. The electric panel is all from the front side, and I have a panel where I can access the electric if I ever need to do anything. However, it will be brought down. What I'm requesting is to bring that structure down and rebuild it the same way, about 2 feet forward, just so that we are inside of the property line. All of his issues with the plumbing and the drainage will all be gone because I will connect to the sewer. There was never any service required. A few things about his pictures. One, the one that had the water all over the concrete, that was on January 22nd. We had a freeze and the pipe bust in the back, and before I realized it and I could turn the shut off. That was clean water. There was just an excess amount of water. That's all that was. So servicing is not an issue. We will reconnect it to the sewage. And what we are asking for is to be able to rebuild about 2 feet forward, because I had some pictures on my slide. If you guys want to see, what I'm trying to avoid is if I have to build 5 feet from the new property line, the property line is actually only 3 feet from the side of my house. So 5 feet from the fence, it brings us all the way in. And then once you're done with the construction, that's 8 feet total. And that takes up a lot of my patio. My patio, we entertain a lot. My kids are 11 and 13 years old. They're playing basketball on my patio all the time. I think it's the very last slide is what I was trying to show. So you can see if you see where the table is, the nearest side of the table is where the new kitchen would end. If I had to if I had to do the 5-foot setback from the new property line. That doesn't give my kids room to play. That doesn't give them, and that's what we use our backyard for. It's an entertainment space for my family and my friends. So if we move it forward 2 feet, it takes up a little bit of the space, but we understand that we are encroaching, so we're trying to fix that. Every other issue that they had, we have already fixed. We've already fixed the electrical, the plumbing, everything. I think that's all I need to say. But
Any questions?
Yeah, so just again, I'm asking to be able to rebuild it a few feet forward and get everything up to code.
Okay.
The fence, I mean, whose
So
is that?
Are you? So the fence originally was. I mean, I thought it was ours, but it was on their property. So they took it down. It was theirs. That was February 27th, and that was the first time that they have ever complained about my kitchen. My kitchen has been there since 2020. When the fence came down, that's when they started having these complaints. They never had an issue with it before. I need a fence because I have 2 pit bulls. You saw one in their picture.
But you also have a pool, and I mean,
Exactly.
the fence is required by code.
Exactly. I have a pool, and all of the kids in the neighborhood, my neighbors know, after school, I will sometimes have 20 kids come over because they come. There's a Linden, Idlewild Elementary is down the street. That's where both of my kids went to school, and the kids will come over after school all summer long. And so I don't want kids to come over and see an opening and jump in. That's every single picture they posted or showed about stepping or trespassing was all with the fence down. It's always like a ball falls into their yard and we get it. We won't do anymore. But that being said, I'm willing to put up a fence myself and then do the kitchen if they won't do it. But I know that they want the only conversation I had, a real one with their lawyer, was him telling me to hold off on putting up a fence because my most urgent issue was I needed a fence for safety of the neighborhood. And I told him, if they don't give me a time, I'm going to do it now. The reason I didn't was that the staff recommended that I not do that because, but I also, I'm worried that my kids are going to open the back door to play basketball and my dogs will get out and go bite somebody. I'm worried that, somebody's going to come and jump in my pool when I'm not around. And so if they won't give me a time, I'm going to put up a fence, and it will be a 6-foot tall fence or whatever I can do. It won't be the 9-foot tall cedar fence that they want. But if they can give me a time and say we'll put it up here at this time, we can work together.
Okay. Any other questions?
All right. Thank you all for your time.
Thank you. All right, so let's see. We could get a motion to approve. My number up real quick, sorry. BOA 2026. What is it?
2026-0020.
2026-0020 as conditioned by staff.
Approve.
Second.
Any thoughts?
So that I'm clear, with the new line drawn, or the property line, he's already 3 feet in encroachment. Is that what I heard?
Not 3 feet. It is 2.5 in the very back to the inside of that masonry wall, so it could be a little more. Where the kitchen is, looks like about 0.9 feet to the inside of the wall.
Gotcha.
That's what it looks like when I looked at it on my computer. We're already in discussion. Thank you, though. So it's, the full encroachment's closer to that, probably.
Gotcha.
Yeah. Any other questions or thoughts?
Mr. Chairman, I do have one.
Yes, sir.
The applicant said that there was a survey that he had done, and that now the gazebo issue is no longer a variance that he's requesting. Did y'all understand that?
Well, I think I understood what he's saying. Everything shifted 2 feet the wrong way. So if we move that, I guess that'd be the eastern side 2 feet, he's probably okay on the new survey. I don't think it helps us with the back of the gazebo, though. That would help with the side of the gazebo.
Okay. So right now, as it stands, the 2 variances that he's requesting is a few feet for the gazebo and a few feet for the kitchen.
0 setback for the kitchen and a few feet for the gazebo. But I think the back line's good on both of them.
Mm-hmm. Okay. Thank you.
My thoughts again is the things that he has done that are now code compliant will solve most of the immediate issues with the outdoor kitchen. You know, obviously he's going to have to figure out how to service it without going on, or even how to build it without going on his neighbor's yard. But again, that's for him to figure out. You know, if they got to block it from the front and paint it from the front, that's the burden on them to figure out how to do that if the neighbor does not want them on the yard at all. But the things that were code deficient, except the variance for the setback, seems to solve the issues. Now, you're never going to get over a fact that you got 82% impermeable surface that's going to always create some level of runoff. So I don't think we can do anything about that. But I think what he's doing from a structural standpoint, allowing the fence, whether it's 6 feet or 9 feet, to be placed in without any issues, in my mind, meets the letter of the intent of doing the right thing.
What is the purpose of a 5-foot setback? I know, like, for the big structure, you're thinking we don't want houses so close that there's fires and stuff like that. But as far as like accessory structures,
I mean, one of the main things is probably about maintenance, because you can imagine the closer you build, the harder it would be to access to, like if your house was only 2 feet off the setback. Because I think, like the code, we even have like 0 lot line houses, but those require you to do a 5-foot easement on the adjacent property in order to do it as part of those subdivisions, because they know maintenance issues will obviously happen without that easement if neighbors don't get along.
okay. Other thoughts? How about this? I don't think that. Do we need to approve? Like, we don't have a copy of his new survey. We could just approve that gazebo is allowed to be where it is. Does that make sense? Because we may not need a side setback, is what I'm hearing.
Yes, because if you approve it, and then essentially we can write the notice of disposition, and then we can have a thing that says there's no approved drawing because we need them to revise the drawing to reflect the new survey.
Okay.
Give us the exact measurements.
Is there any specific discussion as to the gazebo? Okay. Is there any specific discussion as to the 0 setback for the kitchen?
I guess my only concern would be, I guess, in the spirit of the code, of the maintenance of it. If it's just a concrete kitchen, but we're now thinking, what, electrical to it, or?
I think that's all been done. I mean, that can all be from an install standpoint or a service standpoint. If he has a service box from the front, there would be 0 reason to go on the back.
Okay.
If everything is, I mean, and again, that's on the burden of the installer. Everything has to be installed in service from the front, which it can be.
So how would you differentiate the outdoor kitchen from just something else? A shed or something else that can be built on the fence? I mean, like the code has said we need 5 feet. So what makes this unique and different to not, the code not need to apply?
I think one important, to me, one aspect is the height of it. It will be hidden by any standard height fence, whether that's 6 feet, whether that's 9 feet. If that fence is there, you will never know that's there. And to that point, I think that 5 feet is servicing something is generally why we have, in my mind, why we have these side setbacks. You can argue what was the original intent of setbacks in the first place, but I think servicing them, I think it was, they just took what a residential setback was and said that's for the entire thing.
I will say it was above the old 6-foot fence
Which is why they were going to let.
to do a really tall fence there. I just want to make sure the record's clear on that. I don't know what I think about that.
If that's a huge thing, I would condition a minimum height of the fence to cover it.
Where's he gonna put the fence? He's gonna build it on his neighbor's property? He's not leaving any room on his property for a fence. He's going 0 setback.
Fences are always kind of weird, though.
They are weird.
I would say, right, fences are often built around 0, and how do you do maintenance on the other side of the fence?
Yeah. Like even if the neighbor put the fence up, where would they put it? Would they put it right on the property line, or would they bring the fence in a little bit to install it?
I may have to, because they got 0 foot they can't deal with.
Well, the fence needs to go up first.
I would think.
I mean, the fence.
Kind of establishes that.
Right.
Because if the fence is right on the property line that separates them, which typically it's pretty close.
Yeah.
That has to dictate where the where the outdoor kitchen goes, not the other way around. Unless he brings his grill more so in, which, obviously he doesn't want to do, but you can't let that dictate where the actual fence is. It seems like this fence can only go one place to appease both parties.
Yeah, it needs to go as close to the line as possible. I agree with that. Is there any interest in a reduced setback but not a 0 setback? Any suggested amount? I think you need to do normal 5. I think, those houses, though, they didn't have the 5-foot setback when they were built. It was closer to like a 3 or 3.5. So, which, you get a mower back there. You can move in between it and do stuff.
It has to be, I don't know about a specific number, but again, I think it needs to be enough to allow the fence to go right on the property line. So if that's an additional foot, if that's 6 inches, I don't know, but it can impede the fence.
I'm thinking more like 3. 2, a normal, a lot of times, one of the reasons they have the setbacks or they don't want to have I don't know if you've ever been in a place where they have an old carport or garage in the back and it's like 6 inches and that's a great place for rats and stuff like that, as opposed to, 2 feet, except for the largest of us, we can all fit back there, pretty easily to keep it clean and blown out and stuff.
2 or 3 or 2.5.
I would say 2 is sufficient to still, if we're stuck, if we're sold on having some level of setback, I would max it out at 2, because the more you go up, the more you start creating the issue that we're here for in the first place. And 2 still gives you plenty of space to service as far as even with a weed eater or whatever you're trying to do back there. Maybe not a lawnmower, but you know. But this is not also not extending the whole length of the fence either.
Okay. So what distance would y'all like to put in for the setback? I hear 2.5, so splitting that.
Is 2 feet enough to fit back there? I mean, if you're trying to, I don't know how long it is, but you're trying to cut grass back there, you back there to, you know, to do any maintenance, and you know, can a person really fit, you know, maybe 2.5, I'm thinking 2.5 or 3 feet might give you more room to get back there. Now, I don't know how much that works for the applicant, you know, because it's gonna, you know, push the property up, but 2 feet is not a lot of space to.
I would say
concerned
3.
about maintenance.
I think so. Could be 5. I mean,
I only say it 2 because again the burden's on him. If there's something back there he needs to get or clean, you know, the burden's on him. You know, he's sacrificing that for more space. So
well, to go over his setback.
yeah,
Like, he's not just sacrificing, he's coming here with an ask. There's nothing he's sacrificing.
that's a good point.
That's all I'm saying. You know, like, he's supposed to be at 5 feet. Like, I don't think he's given up anything except he's pushing stuff up into his, you know, that kind of neutral space.
When you put it that way.
Yeah. So that's why I think 3 makes more sense. Okay. So we have a motion. Is there any objection to changing it from a 0 setback to a 3-foot setback
No objection.
for the outdoor kitchen? Okay.
And just for clarity, it's the opposite way. We're allowing a 2-foot setback encroachment.
Okay. Agreed. Thank you, Mr. Secretary. Any other thoughts before we vote? Okay. If you'll give us a roll call, please.
Mr. Love,
Yes.
Ms. Conrad,
Yes.
Mr. Claybrook,
Yes.
Mr. Bruce,
Yes.
Mr. Campbell,
Yes.
Ms. Skurlock,
Yes.
Vice Chair Savage Selden.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
Yes.
Motion carries.
All right. Thank y'all very much. Mr. Secretary, we call our next case.
Item number 4, BOA 2026-8 at 4512 Trout Valley Drive.
All right, is the applicant present? Thank you. Position. And then if there's any opposition to this, well, I know there is opposition. If you can come get a seat kind of closer to the front, that'd be great. And then, are you Miss Williams?
Yes, sir.
Okay, you can go ahead and have a seat, and we're going to have a brief staff report, and then we'll get with you. Okay, perfect. Thank you so much.
I'm presenting BOA 2026-008. The request is a use variance from section 2.5.2 to allow a group shelter, which we term it as a social service institution. It's zoned R6. It is surrounded by predominantly single-family land uses. We sent out notices to 171 property owners. This is side photos of the subject property, and this is a side plan showing the subject property. And again, in the UDC, it's classified as a social service institution. So like the previous cases, the applicant wants to use it as a supportive living facility for a commercial purpose, but the UDC does not allow it to be commercial. And also, the applicant did mention that the single-family home is larger than usual, and that's why they wanted to use this for a group shelter. But it's part of a subdivision that was approved in 1975, 3-bedroom, 2-bath. It's very similar to the houses used there, and so the property can be used as a single-family home, and also group shelter is a permitted use if the applicant wanted to use it for a non-profit. So we are recommending a rejection, and if approved, the applicant should plant a one-type A street tree, and any changes to the site plan should come back to the zoning administrator. Thank you.
Okay, thank you very much. Are there any questions for staff? All right, Ms. Williams, if you want to come up and talk to us, if you'll give your name and address for the record.
Hello, my name is Marquita Williams. Address is 4512 Trap Valley.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead and share with us.
All right, my name is Marquita Williams. I am the founder of Impact Mid-South. I have over 16 years of healthcare experience, and I have worked closely with individuals in this community. The purpose of Impact Mid-South is to provide a safe, stable, and supportive residential housing for veterans within our community. This includes individuals experiencing living with disabilities, maybe facing behavioral health problems, or just basically transitioning back into society for independent living. Our mission is to create a structured and supportive environment where residents can receive guidance, stability, and access to resources that help them improve their overall life and long-term independence. In addition to housing, we plan to assist residents through supportive services such as behavioral health support, respite care, healthcare coordination and referrals, community involvement, and of course, assisting with life skills and community reintegration. I also want to, it is also important to emphasize that this property will continue to maintain the appearance, atmosphere, and function of a residential home. This will not operate as an institutional facility or commercial operation. Our goal is to provide a quiet, well-maintained home environment that blends naturally within the neighborhood while serving individuals who need supportive housing and care. We are committed to being respectful neighbors, maintaining property responsibility, minimizing disruption, and ensuring the home remains safe. That's very important, and professionally managed at all times. This variance will allow us to address a critical need within our community while continuing to uphold the integrity and character of the neighborhood. As someone with extensive healthcare experience, I have a passion for community service. My goal is to help vulnerable individuals, such as our veterans, to have access to stable housing support and resources that they need to gain independence and reintegrate back into the community. I also want to point out that with this home health care service, there will be a variety of things offered for our veterans. It's not just for housing for them. They will receive medical care, they will receive resources, they will be referred out to whatever it is that they need. This facility will be under the direction of all medical staff, from medical directors, nurse practitioners, nurses, all the way down to medical assistants. Basically, in order to get the veterans into the home, the plan is to work closely with our hospitals, local hospitals, social workers, caseworkers, especially like the VA and just local hospitals, in referring us the actual veterans that need our service. Let's see, was there anything else I want to address? And of course, I am requesting this variance because it is a nonprofit, it is for profit, because payment would definitely be coming from like insurance companies and private pay veterans as well. But other than that, the goal is not to change anything about the home. The home will operate as a residential style home. The home is compatible for a shared living facility, And the goal is to house anywhere between 4 to 6 veterans at a time. And that's it.
Okay, are there any questions for the applicant?
How large is, how many bedrooms?
In the home, it's 3 bedrooms, 2 baths.
3 bedrooms, 2 baths?
Yes, sir.
Have there been any modifications done to the home to
No,
make it
sir.
more? Okay. Okay, other questions? We do have some people here to talk in support as well.
Yes, sir.
We have some time for that. So I have Tony and Tia Davis. Are they here? Tony or Tia? Your support may have left. Do you see your support anywhere? Do you see the Davises? Well, they were going to support you, but I guess they gave up.
Yeah, I was like, I don't know. And they may have stopped and talked to me in the neighborhood, and I
Yeah.
just didn't,
Well, I mean,
remember
they
their
were-
names.
They were here.
Okay.
So I don't know. They may have wrote the wrong case down and their case got approved or something already. So that it may have been that. So any other questions for the applicant? Do we have any time left over? So you have like 5 minutes left over from the 10, and so you'll have some, because I do have an opposition card.
Yes,
So
sir.
you'll have up to 7 minutes in rebuttal if you need that.
Okay.
Okay. So we're going to move on to the opposition. I have a card here from Ms. Carr. And if you'll give your name and address for the record.
Good evening. Luella Carr, 4431 Trout Valley Drive.
Okay. And do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, go ahead, Ms. Carr.
Residents have serious concerns regarding both the proposed use of property and the public notification process related to this hearing. Many residents in the surrounding area were not properly notified about the proposed group home and did not receive notice to the hearing at a timely manner, if at all. In addition, residents who contacted the office regarding the hearing were reportedly provided with incorrect information related to the case, creating confusion and limited meaningful public participation. Our neighborhood is already dealing with ongoing concerns involving crime, illegal dumping, property neglect, safety issues, and other community challenges. Many residents believe placing a group shelter in this residential single-family area could potentially create additional strain and negative impact the quality of life, safety, and stability of this neighborhood. At this time, we respectfully oppose the placement of a group home in this area and ask that alternatively occupancy or a more appropriate location be considered elsewhere for this facility. We respectfully request that the board carefully consider the concerns of the surrounding community and deny the requested variance. Now, I should let you know that I'm sure y'all don't remember looking at my face, but this is my first time. And so I may be, well, I'm sure I'm unprepared for the most part, but it was a very short notice in receiving, because as a matter of fact, I'm probably one out of 20 people that probably received the notification. And it came to my attention because I did receive it in the mail. Several of my neighbors, as I said, are concerned and don't want it, oppose it. I have some signatures as well, people who stated that they were against it. And I don't know if that's
Yeah, if you could pass
appropriate
those.
to get signatures.
Do you mind passing those to her and she'll let the board take a look?
that's not enough, I will get some more. Because, yeah, because there are a lot of people really not for it, don't want it. And Marcia Carr is my daughter, and the people in the area have become acquainted with her because she's always trying to upgrade our neighborhood. She's always picking up debris and trying to keep the neighborhood in order. I have not seen anybody else other than Miss Denise Williams and myself. And so, as I said, we have enough illegal dumping and crime, and, you know, we don't need it extra, you know.
Okay.
And there's a Miss Nancy Foster that also is my neighbor that works at the Delta Medical Facility, and she has told me on numerous occasions that she's familiar with how the group homes are set up, and that it would be chaotic for us to, you know, if you granted this, you know, request, that it probably would be real bad for us, the neighborhood, with increasing crime and, you know.
Okay. Are there any questions for Ms. Carr? Okay. Do you want us to give, you want that back? We'll get that back to you.
Okay,
Just so you know.
that'd be
Okay.
fine.
Okay, thank you so much, Ms. Carr.
As I said, if you need some more signatures, I'd be happy to oblige.
Okay, thank you.
Thank you.
All right, is there anybody else here to speak in opposition to this Trout Valley case? Okay, Ms. Williams, if you want to come back up and if you want to rebut anything.
All right, so I kind of think a lot of confusion is coming from the term group home being used within the community. I don't think they realized that last week my son was walking through the neighborhood and one of them pulled him over to sign this petition, not knowing I was his mom, and it was me starting this business. And so when he was told what was going on, he said, well, do you know what the business is for? And this is exactly what they stated, group home. And so when you think of group home, you're thinking of just transitional people, just transitioning people in from all different aspects, regardless of what they have going on. And there isn't a true definition of what their understanding of what I'm creating here. So when he called me over the phone and I stated what I was doing, whoever the individual was, she stated, oh, well, I hope that's exactly what you were doing. He said, but I wanted you to state this because I had already explained to them, and I wanted you to get on the phone to explain to them again. So I think it's the terminology here. Of course, I understand the verbiage that's being used, and this here is not a group home. This here, it can be considered supported living facilities, and it also is considered home health because of the services that are being offered. The veterans are receiving medical care. It's really no different from me having a home health agency and I'm dispersing workers out into your home to take care of you for skilled nursing or whatever the case is for you. The only difference here is I'm actually housing the people that I'm going to be taking care of, me and my staff. So I understand safety can be a concern for most people. From what I was also told, that something like this may have happened in their neighborhood some years ago, and said people was walking up and down the street, outside smoking and drinking. That's not my intention. I run a tight ship. And so home health is just an extension of things that I can do. I've been in emergency services for a long time, so I have seen a lot of different things and I still see them. And so, of course, the services that we're offered, they're going to be monitored 24/7. There will always be staff there. Anybody pretty much coming into this establishment, they will have to be evaluated. If it's something outside of the scope of care that we can handle, they will not stay in this, they will not stay there. So I think it's the terminology that's actually being used. I am for the safety of the workers, of the residents, and of the neighborhood. I don't want anyone being harmed in any type of way. This is just about providing continuation of care in a residential area.
Can I, quick question. How long are typical people that stay in here, veterans, how long are they staying here at any given time? Are they in and out? Are they staying for at least a certain amount of time? What is?
Well, basically, a lot of them, they need housing. So this will kind of pretty much be permanent for them unless something happens to where they have to be transitioned out, or if they, they may pass or something like that. Everybody the population that I'm looking to cater to, of course, 55 plus. As I stated, they need continuation of medical care. They need help with just transitioning back into a normal life and whatever others, some of them may need assisted daily living. They may need someone to help bathe them, to help, cook their meals, wash their clothes, So the population that I'm actually looking to cater to, they're pretty much going to be home bodies. They're going to be in the house. And of course, I want them to be able to still have community involvement. When it comes to things like that, that's something we'll put together and we'll take them out places. It's not for them to be hanging out in the neighborhood at all.
Okay, other questions?
Yes, I have a question. From earlier, it seems to be, have you explored, becoming a nonprofit? Because nonprofits can accept insurance, they can accept payments, they don't generate a profit, but they can pay the administrators and they can take in fees, but that would, satisfy the group home designation.
Well, no, I hadn't looked into a nonprofit. Really, the first I've heard of it is I've heard of nonprofits, but just in related to this case is when I did the application for the variance. And I think Mr. Skinner was the one who told me that, in order to get the variance, it would have to be a nonprofit, but anything additional, you would have to apply for the variance.
Gotcha. Thank you. That's the
Yes,
question.
ma'am. Thank you.
Any other questions? Okay. Yeah, go ahead.
Yes, sir.
Thank you, Ms. Williams. Just to clarify, the house itself is a 3-bedroom?
2 baths, yes, sir.
3-bedroom. And what you are planning is 4 to 6 residents?
Anywhere between 4 to 6 residents, because the rooms the layout of the rooms are compatible for a shared space. And, but like I said, we can house, it wouldn't be no more than 6 people. It might only be 3 people, just kind of depends on what the patient has going on and what we need to offer them.
Okay. And staff, is there going to be overnight staff?
Yes, sir. Round the clock.
Okay. Will they need a place to, I don't know, will someone be sleeping there that's a staff person?
Yes, sir. So, it'll be your typical shift, whether we do 12 hours or 8 hours. It could be 7A to 7P, 7P to 7A, or your typical 8 hours, 7 to 3, 3 to 11, 11 to 7.
Gotcha. But the staff won't need a dedicated bedroom for them?
No,
The bedroom
no.
should be for the residents?
Yes, sir. They're there to work,
Okay.
and, to make sure everything is operating the way it needs to operate.
Yes, ma'am. Thank you.
Yes, sir.
Has this currently operated in this capacity, or is this going to be something that's new? And if it's not new, is there another location that you currently operated?
No, sir. This is new.
Okay.
Okay, any other questions?
One more question.
Yes, ma'am.
Would you transport the residents to and from doctor's appointments and other, affiliated?
Yes, ma'am.
needs? Okay.
Mr. Chairman, we just had a point of information. Truce is pulling it up right now. The floor plan in the staff report only shows 2 bedrooms, so we're just, if the applicant could respond, is this not accurate, or?
It's 2 bedrooms downstairs and it's a 1 bedroom up.
I see the stairs.
Oh, okay. I
Yes,
guess we just
sir.
don't have the second story. I was just
That makes sense.
confused.
Okay.
One story, which also contradicts.
Is that the one that the guy drew up? I had a guy to come out and draw up a site plan.
Yeah, page 10 says it's 1 story.
I mean, definitely drew steps. You know?
I know.
Yeah, so it looks like it's probably a 1.5 story, and the attic was converted to a bedroom.
Okay. All right, any other questions? All right, thank you very much.
Thank you.
So if we can get a motion to approve BOA 2026.0 or -0008 as conditioned by staff.
So moved.
Second.
Any thoughts on this?
In a few ways, I'm not gonna say a lot. In a few ways, it has some very similar concerns with I guess the first one, where if it was support services by right, they can do it. But you know, that's why I asked the question about how long will people stand, because I thought it was transient. I mean, I thought that was I thought the definition. Well, I must have misread it, but I was thinking people were coming in and out like freely, like it's
right.
Now the density of this area seems to be a little different than the other one.
Yeah, I mean it's in a neighborhood.
It's in a neighborhood. It's in a
you know?
neighborhood. So that's where it gets a little dicey. But so I mean, I'm this one's slightly different, but
Yeah, I mean, the other one, bigger acreage. You don't go through any neighborhoods to get there. If you're familiar with Watkins, Robertson, and Memphis town.
It's been the same use.
It's been the same use for 20-something years that they've been doing, and it was built to do that.
Unusual characteristics had on here, and I'm
Here, I
going-
think we have a house. And
Right.
it's just as good for this as any house.
and I don't, and I definitely have a concern with 3.2 being used in the capacity that they're attempting to use it in. You know, I didn't see. I mean, looking at it, the rooms didn't appear to be like that large that you will justify maybe 6 people doing it. You know, I guess the other one was kind of built for that and modified for that, and that's what the condition of it was. This one feels like it's a house that's being adapted for that use.
It hadn't been adapted
It
yet.
hasn't been adapted yet.
Also, the residents of the other home were fully ambulatory. They from foster care. This is an older population, which may need more ADA access.
Yeah, I'm just concerned because if we're talking veterans that are getting services, and the quarters are very small, where will they get their services? I'm just concerned about the sizing, and getting that many people. Again, this is, each case is different. You have to look at it as such. I'm just concerned that I don't see the hardship. I don't see the hardship here.
I mean, the other thing you have to think about too is, even on the other one, while we knew how they were going to use it, we allowed it to use that way, and they could change their plan once it's that group home or whatever. So even when you have an operator that you think is going to do a good job, you still got to look at like, okay, something happens, she's not there. Now this house is a group shelter for anyone that wants to operate one. And when it's in the middle of a neighborhood like that, I just don't.
It seems like one of those
great about it.
situations. Since it's a new entity as well. It's not. This is one of those situations where I do think it makes sense to explore the nonprofit avenue, because then you don't need our permission.
Correct. I definitely agree. That may be the best route, is to go about that way, because it has its own servicing and oversight.
Yes. But as it stands right now, it doesn't feel like something that we're going to feel strongly about.
Right.
Yeah.
Any other comments before we vote? All right, Mr. Penzis, will you give us a roll call, please?
Ms. Gerlach,
No.
Ms. Conrad,
No.
Mr. Bruce,
Because I missed the first part of the presentation, I'm going to abstain from this one.
Mr. Campbell,
No.
Mr. Claybrook,
No.
Mr. Love,
No.
Vice Chair Savage Selden.
No, I find that the standards of the UDC of 9.22.6 are not being met, and they will be duly detrimental to the properties in the vicinity.
And Chair Rainey.
No.
Motion fails.
Motion fails. There are avenues to do something there with the different type of entities, so if the applicant wants to explore those, they can. Mr. Penzis, will you call our next case?
Item number 5, BOA 2026-10 at 4427 Deerland Street.
Okay. All right, if the applicant can take a seat, and is there any opposition here for this case? Okay. Ms. Christian, you can give us a little report whenever you're ready.
Good afternoon. I'm Chloe Christian with DPD. I'll be presenting this case, BOA 2026-0010. The applicant is here with us today, Ms. Elma Smith. The property is located at 4427 Deerland Street, and this is a use variance to allow a transitional home to allow 6 mothers as part of a mothers and infants reentry into housing program. Here's a location map and vicinity map of the property. As you can see by the vicinity map, the property is located within a residential subdivision. The rear property line is also abutting a high school, Westwood High School. Here's a zoning map of the property. It's zoned R6, and the surrounding land uses, as I mentioned, are predominantly single family with the high school, and there's also an elementary school to the west. Here's a photo of the subject property. It's currently a 2-story single-family home, and there are no changes being proposed to the build of the home at all. Here's the site plan submitted by the applicant. And these are the floor plans submitted by the applicant. This is the first floor on the left and the second floor on the right. There would be, I believe, 4 bedrooms. 6 bedrooms, thank you. 6 bedrooms proposed, with 6 mothers maximum proposed to reside in this structure, as well as resource rooms, office rooms, kitchen, visitor room, and training rooms, where services would be provided on site. So, in conclusion, the proposed use would provide housing for 6 mothers and 6 infants as part of a mothers and infants reentry into housing program, and also provide aid to residents along with 24-hour supervision. There would be services like case management, reintegration planning, and therapeutic and medical services as well. Residents would stay anywhere from 2 to 4 months on the subject property, and depending on the stipulations of their agreement with the program, they would either be released back into the community or placed into a reentry program or placed back into finishing their sentence in a federal institution. If approved, we do find that this use would not match the established residential character of the existing neighborhood, given that the property is located on a local street with single-family residences. We find that this use is not appropriate given the specific location of the property. In addition to that, the property can be used as it has been used as a single-family residence, and there's no hardship or practical difficulty presented to justify an approval of the variance. So we've recommended rejection of the case. However, if approved, we recommend the standard condition. And that concludes my presentation. Thank you.
All right, thank you, Ms. Christian. Are there any questions for staff? This has nothing to do with being a nonprofit or or a for-profit business, correct? That's not part of the transitional housing.
Correct.
Okay. All right. All right. Any other questions before we move to the applicant? Okay, if the applicant will come forward and give your name and address for the record, please.
Okay. I'm Elma Smith. Kyla Carr, 747 Timber Creek.
Same address? Okay, just making sure.
And she's going to do the presentation. I just got up to to be her support.
No, I appreciate it. Okay. Y'all swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, go ahead.
Okay, so we're Christian Care Services, LLC. We'll be going over the property at 4427 Dearland Street. Go to the next slide. So the program will be for mothers and infants nurturing together. It'll be structured around residential reentry housing. We'll serve federally approved mothers and infants, focusing on stabilization, parenting, and successful reintegration. The resident is approximately 2,938 square feet. It is a 2-story resident located in established residential neighborhood. There are 6 sleeping rooms with supportive common areas. This will maintain residential appearance and character. The home will have 24-hour supervision and staffing, security monitoring and control visitation, emergency evacuations and procedures will be in place, transportation coordination for appointments and services, and we will remain in compliance with the federal and local operational standards. Some of the services provided here will be parenting and infant care education, case management and life skills training, employment readiness and reentry planning, counseling and behavioral health referrals, prenatal and pediatric care coordination. The facility is designed to minimize neighborhood disruption. There will be low occupancy residential setting. Structured supervision reduces community concerns. There will be no jail, detention center, or correctional operations on site. Support family reunification and public safety. This will reduce reincarceration through structured support, promote the infant development, assist mothers transitioning back into the society, encourage employment and stability, strengthen long-term community outcomes. We will maintain residential character of the property, comply with life safety requirements, adhere to operational policies and staff plans, and have continued coordination with local agencies and stakeholders. Christian Care Services LLC respectfully requests approval for the proposed Mint Residential Reentry Program with the contact of Ms. Emma Smith. Telephone numbers listed below. At this time, we will review the neighborhood FAQs, which address neighborhood compatibility concerns, clarifies operational safeguards and supervision, and provides factual rebuttal to common misconceptions. There is no certified evidence presented showing professionally managed maternal housing lowers property values. Property will maintain residential appearance. Structure operations differ from unmanaged rental properties. 24-hour oversight and operational accountability will be provided. The facility is not a jail or detention center. Participants are federally approved mothers with infants. Curfews, monitoring, staffing, and visitor controls will remain in place. No uncontrolled public access to the property. We will maintain residential character of neighborhood, responsive communication with neighbors, property upkeep and maintenance standards, coordination with local agencies and public safety. The Mint program supports rehabilitation and infant stability, structured, professionally supervised residential environment, compatible with neighborhood character. Christian Care respectfully requests favorable zoning consideration.
Okay, are there any questions for the applicant?
Yes, I got a question. You say it will be, you report to, like who is responsible for making sure that you're compliant with the standards you set forth?
The Bureau of Prisons is who we are working on a contract through them, the Bureau of Prisons. The Federal Bureau.
Gotcha. And so they certified this, the program, and how often do they come out to recertify?
Well, they did not, this is the first contract that we've actually tried to get with them. And we're at the ledge stage now because they're looking for because we don't have the variance to say we can do the operation in that community. So they're just waiting for us to say, hey, you all approve us to do the home for the contract there.
Yeah, but I'm saying, say it's approved. Do they come out one time and then say you sell the home, and who says that this is continuing to operate as designated?
They oversee and they monitor, but it's sporadic. So like you have supervisory visits and you're not supposed to know when we're coming. So they do surprise visits, we'll say.
Is there
Can I add one more thing to your question? Also, it's a lot of paperwork to go in place, as into who's coming in and out of the home, the staff, the counselors. Everyone has to be exactly who it is. So if there is a staff, let's say that we have something going on with staff, and that staff can't come. We can't just use anyone or get anyone to come in. You have to be certified by the Department of Justice in order to come into their home. So we can't just use this person, that person. Everyone has to be certified to be there.
Yeah, no, I think I got the answer to my question. Thank you.
Was this property used for similar or same services prior to your obtaining this property?
I'm not sure before we obtained the property. I'm sorry about that.
Other questions?
I have a question, but it's more for staff, I guess. Say this is approved, and then later on again, it goes with the property and they decide to sell. Is it then, can it be, I guess, go into being a group home status at that point? Is it is it just wide open for being?
This program for us is for me. I'm sorry, was that question for me?
No, it's for
Oh,
staff.
I'm sorry.
So as it is worded, I mean, anyone else in the future could operate it, but it would be a transitional home specifically for 6 mothers as part of a mothers and infants reentry housing program. So basically, you'd have to do the same thing.
Okay.
This is also for staff. I know on the previous cases, there was a by right usage that closely resembled what they were trying to do. Is there one on this particular case that is a by right that?
No, this falls under a social service institution.
So not even.
And it's not by right in any district.
Okay.
There's like, I think 3 commercial districts and 2 industrial districts that require a special use permit. But
Okay.
That's it.
And this is for you all. I saw the floor plans. Is that how it sits today, or are these renovations that you are proposing?
No, sir, that's how it sits today.
Okay.
Question for you. With this particular program with the Bureau of Prisons, do they have any location requirements on where they want it, or does it just need to be in the city somewhere, or just wherever you want to put it? I'm just like, does it need to be in the middle of a neighborhood? typically? The residents, do they have cars?
Yes.
No.
No, I'm sorry, I thought you meant the adjacent residents.
No.
Yeah, no,
Okay.
the
But
residents.
people
are-
that are living there typically
No,
don't have
no,
cars. They use the van to get
No,
around.
they don't have to, they don't have the ability, they're not capable of driving.
Gotcha.
They are capable of evacuating the building unassisted if possible, if needed.
Okay. All right. Any other questions?
I got one quick question. Is the max of 8 residents, is that something that's,
Permitted by right.
is that also a kind of a state licensure requirement, or is going up to 10 gonna put you into another category that has to be relicensed by the state?
No, she's, her license right now is, we permit her to go up to 13, the license she actually has now, from what I've seen on her paperwork. But the only thing, over the 8 will require the sprinkler system. And she has already installed that, had it been inspected and approved by the local fire chief.
All right. We'll move on to the opposition. You've reserved some time.
Yes, sir.
Okay. So we have one opposition card. If you want to come down, ma'am. And if you can give your name and address for the record.
Hello, my name's Elizabeth Carroza. I live at 5649 Rensselaer Drive in Memphis, Tennessee, 38135.
Okay, and you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, ma'am.
We became aware of this situation when I looked at the Land Use Control Board minutes a couple of weeks ago and saw that they were requesting a variance for a residential home for the elderly. It's an area zone R8. It's purely residential. We found out that they had been operating a nonprofit business in the home, such as a boarding house type situation. We wondered if this was a licensed business because we're not aware of the business license in the area. The person listed as a property owner is Robert L. Rayner, and the applicant listed is Ada Rayner. And I think it was my understanding she lives in Cordova, not at that address, but that can be verified. The scope of the business has the potential to negatively impact the nearby neighborhood with increased vehicular traffic on Bedford Road, which is a dead end. It's a narrow street with numerous vehicles parked on both sides already, decreasing driving space, and we did send some pictures. You can take a look at those. This is not a through street, and there's no turnaround at the dead end. The short driveway at this house will accommodate a very limited number of vehicles, perhaps 4. The potential for emergency vehicles may be increased with the addition of elderly people. There is insufficient space for an ambulance, a fire truck, and law enforcement to be on the scene and have sufficient mobility. And you can look at the photos and see how close they are. The potential negative impact on property values for existing and future residences could be apparent. Questionable ability of the facility management to ensure the safety of the clientele and also of the neighbors in case of mental health issues in the middle of a residential area. And this is not a large piece of property. I believe it's only 60 feet. It is deep, about 204 feet. Questions exist as to completion of assessments and licensing as an elder care facility, the staffing ratio, mobility, and sufficient exits, fire inspections, sprinkler systems, sufficient and legal bathroom facilities for elderly. If there are going to be 10 people in this house, there are only 2 bathrooms, I believe. And there also will be staff. That seems insufficient for a house for that many residents. Food inspections, etc., increased traffic to the area due to these requirements, and visitor traffic to the home also needs to be considered. We wondered what the current and future occupancy is. And one other thing, we would like to see that petition. We have not seen it. That is a small neighborhood, and there seemed to be maybe 25, 30 people who signed that petition, and we were just questioning the validity of it for the area. I have with me Kathy Blakely, who is not going to speak, but she does live in that area and was not aware of the petition. So we are requesting that this be denied. We think the idea of having a senior living facility is indeed important, however, not in this type of residential setting. Thank you.
Okay, are there any questions for the opposition?
Well, I just wanted to make a comment just to make sure that we're clear. I think the question is whether we go from 8 to 10.
I can't hear you.
The question is he legally able to go from 8 people to 10? But he's legally allowed to have this act as a facility regardless. Like that's his by right per the code in the zoning. He can have 8 people without even coming to us as a.
Well, this
to get
is a
approval.
single-family residence area.
Well, I'm just saying that's the way the code currently reads, the UDC. He's allowed to have 8 people with no permission. So some of the points you brought up about ambulance, those are going to be an issue regardless of he gets 10 or 8. He's legally allowed to have 8. I just wanted you to make sure you understood that. He can have 8 people without getting permission from us.
If that's what you say. Thank you.
Well, it's what the code says. All right, well, if there's no other opposition, we're going to move back for rebuttal. Mr. Smith?
I think that's Ms. Katie or Ms. Lynn. We do have a list we can share with you. And we also requested time with them to sit down and go over everything to try to resolve some things. But I think at the time they were not able to or didn't want to. So we will provide that list. And on the list, each address is posted. The adjacent neighbors were mainly the ones we were focused on getting their signature and making sure they understood. But we have actually 50 people on that list. We completed the whole street, the entire street, and into the cove. And Ms. Rayner and Mr. Rayner have kept that property at its, it looks great. And it's, you can't tell whether it's single family or being used as it is as a assisted living facility. And all the neighbors there support her. And we just hope that y'all would support us also.
All right.
Y'all have any questions?
Any questions? Okay. All right. Thank you much.
Okay.
If we can get a motion to approve. BOA 2026-40 is conditioned by staff.
Second.
Moved and second. Okay. Any discussion?
I think staff setting the maximum at 10 is sufficient. I don't think they need to go above that.
Yeah, I agree. Any other thoughts? Okay, Mr. Pensis, you give us a roll call, please.
Mr. Claybrook,
Yes.
Mr. Campbell,
Yes.
Mr. Bruce,
Yes.
Ms. Skurlock,
Yes.
Mr. Love,
Yes.
Ms. Conrad,
Yes.
Vice Chair Savage Selden.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
Yes.
Motion carries.
All right, if you could call our last case.
Item number 12, BOA 2026-41 at 1415 Kyle Street.
Okay, is the applicant present on Kyle? Then we got opposition, okay. All right, the applicant and opposition will come down front, and then we'll have a staff report. Looks like Ms. Nira is up again.
I'm Nabanita Nira with DPD presenting the case BOA 2026-0041.
Okay. Oh, hello. My name is
Hold on a second. I'm confused. Hey, if the last if y'all could continue outside just so we can hear. I'm glad you're talking, but just want to. Yeah, that's okay. And then, are we doing a staff report, or did you say something else? Did I miss something?
No, it's okay. You're gonna swear him in?
No, well, I was going to let the staff report happen first.
Okay.
Yeah, sorry. Okay.
The applicant is requesting to allow a side setback encroachment, approximate 2.4 feet at 1415 Kyle Street. This is the location map and vicinity map. The subject property is zoned RU1. It's surrounded by single-family residential. These are the pictures, but let me show you. This is the current condition of the property. So the applicant submitted a building permit in 2026. During construction, discrepancy was noticed and notified by the building inspector, and the applicant done survey, and then the survey shows that the previous survey was inaccurate, and then now we're hearing the case. This is the site plan, and you can see the side setback, it's showing 2 feet 7 inch. According to the applicant, the subject property is narrow and has steep topography, and this condition limit the practical buildable area of the site. In conclusion, the applicant is asking for to allow a setback for 2 feet 6 inch, and the staff recommends approval with condition.
Okay. Are there any questions for staff? Okay, thank you much. If the applicant will come forward, and now if you'll give your name and address.
Okay. Can the opposition go first, and then I can go after?
I'd like to hear a little bit first.
Okay.
It's that, tell me what's going on, and then,
Okay, so my name is Paul Aguilar.
That's in the rules. It can or can't. I'm sorry. Give me 1 second.
Robert Rowling, County Attorney's Office. To correct what I said earlier on the order of presentation, that is County Commission practice. But our rules, Article 4, actually do say that the order shall be the applicant, proponents, opposition, then rebuttal and deliberation.
Okay. We've often reserved time in the past. Is that still okay? Like if you don't use your full 10 minutes? Okay.
Yes.
Just wanted to make sure. Okay. Thank you for that. Did you give your name and address for the record?
No, not yet.
Okay, go ahead and give your name and address for the record.
Okay, so my name is Paul Aguilar. I live in 2072 Elsie Avenue. I'm representing Ace Capital and Carlos Sanchez.
Okay. Let me swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead and give us a little bit of background first, or what your thoughts are, how we got to be where we are.
So, let me see, I wrote some notes down, so let's see. So the subject property has, sorry. Subject property, so the subject property on the rear and on the right side of the property, the topographic conditions are kind of steep. And there's a cross slope on the right side where there's a driveway. So due to the steep terrain and the narrow dimensions of the lot, it presented a unique challenge when we started forming the concrete. So due to the challenges, that's where we built the house.
Did you think you had enough room on the side when you started to put it there?
Yeah, that's what happened. That's what they thought. They thought they had enough space when they poured the concrete, and then they started bringing the lumber company, and then they started framing it, and then the building inspector came out, and what they said, once the building inspector measured it, that it didn't have the right setback, which was 5 feet. It came out a little bit shorter.
Right. Okay. But that wasn't the intent to begin with. They thought they had it where they.
Well, they moved it because it was sloping on this side, and they were like, "Hey, we're gonna have to get a new block foundation because it's sloping too much on this side. So if we just move it a little bit to the left, then it'll be fine." And then that's when we found out, hey, now the setback is shorter than what it should have been.
Okay.
So that was the issue. So when we spoke with the building inspector, and we're like, hey, what's the best way we can resolve this? Obviously, they said file variance, and they said you can, on that side of the wall, you would have to fire rate it. Fire rate it for 1 hour.
Mm-hmm.
So we looked into it. We can definitely do the fire rating. Basically, I spoke with the architect. They give us a list of what we'd have to do to firewall that whole wall on the left side. The corners, everything has to be firewalled. And when we were doing research when I was doing research, we were reading that the side yard setbacks exist primarily to provide fire separation between structures. So by constructing a code-recognized 1 hour fire-rated assembly on the affected wall, that would protect the purpose of the setback, and it would be preserved through a different but equivalent method. So that's basically our solution right now at this point. The firewall.
Okay. Are there any questions for the applicant's representative right now? Okay, we'll reserve some time for you.
Okay.
If the opposition wants to come up, I got 2 people. Do you want me to call a name, or do y'all know who wants to go?
She's gonna go first.
Okay.
We need to swear in together.
Yeah, you can. Yeah, you'll both give your name and address for the record.
My name is Aura Burns. I live at 981 Peach Avenue.
Okay, Mr. Finch.
Roman Finch, 1493 Cow Street.
Okay, y'all both swear to tell the truth, the whole truth, and nothing but the truth. So
Yes, sir.
Okay, go ahead, Miss Burns.
Okay, I'm here today because I own 1419 Cal, which is next to him. I've already signed my plans. I've already sent my paperwork in, but I didn't know I need to send anything here because I didn't really understand this.
Sure.
Where he's at is absolutely, I have pictures, I have everything. It's absolutely too close. I'm putting a mobile home there because I'm caregiving for my mother. She's 84. If they're there and this close to my house, when I put my house and I put my fence down, my mom will be hearing whoever the neighbors are. They don't reside. They build a house on our street, on our actual street. They don't reside there. Me and my mother will be living there. I have pictures, and I know to show you, him and I both used the same surveys at the same time. I've had to pay for 2 surveys, sir. They can't build without tearing up my land. I have pictures where they've torn up my land. They keep parking on my property. I've did police reports. They've came out several times and asked them, I've lost hair. It's really getting to be so stressful. They're calling me, they're harassing me, and I just really want y'all to know, they did know they didn't have enough room even at the purchase of the land. They've changed names. I can't say how many times we've had to chase them down to serve them. And I just wanted to show y'all maybe my pictures and let y'all know I have did my own plans. I have police reports and how they're just tearing up. They're so close to my property line. They knew this before they even poured concrete. So I don't know what all I should show. Okay, thank you.
You can pass it out, yeah.
And we've been in communication. When we bought this land, they came and knocked on my side door because I lived directly across the street for 20 plus years. And he said, hey, we don't have enough to build. Can we have about this much? And I said, well, no. He says, well, if we buy the one on the further side, would you move over and let us have this? This was 2 years ago. I said, yeah, sure. That never happened. So fast forward, they started saying that it was like eminent domain, that I wasn't caring for it. The city hasn't cut my land once. I cut my land, I pay people. They've cut theirs several times. So, I mean, I don't know. And they've built several houses, so they already knew how much room it would take. When I bought floor plans, and this is my second survey. I had to pay for 2 surveys because they pulled the stakes up, moved over, cut a tree down. I paid $2,300 to cut the trees down that I wanted down, and I was keeping the 2 pecan trees. They just moved over, cut it down, dug my land up, drove all in it with their truck. When I go talk to them, they'll move. When I leave, they'll go back. I've had to even call the police several times, and I don't understand how they're gonna build without coming over on me. And even if they stay that close, we can't even put a lawnmower between there to keep their, yard from growing up over me, over my fence and everything. I'm just lost. It's just too close, and I don't think that will work, and that's all I came to say. And he wanted to speak. I don't know what else we need.
Okay. Are there any questions for Ms.
Okay,
Burns?
thank you all for letting me speak.
Yeah. Okay, Mr. Finch?
One
go
more
ahead.
thing, I'm sorry.
Yeah, you're good.
I didn't get this one printed out. I have a lot of stuff printed out because we're going to civil court. This is a picture that I didn't get printed out, and I apologize. This is to show you that he knew it wasn't his tree when he went over there and cut it down. They cut just the things off, and they can't do that because it was hanging over there, and I understood that. They went back and cut the whole tree down. My pecan tree, my shade. Thank you.
Mr. Finch?
Yes, how you doing?
Good, how are you?
I'm here because I was the original owner of all 3 lots to the left side of my house. And I initially sold the far lot to him. And I told him at the time he didn't have enough room to build when he showed me his blueprint. And then he even came back to me and said, I don't have enough room to build. Can I buy the other lot? I'd already sold the next 2 lots over to Miss Aura. I said, you have to go talk to Miss Aura and see if she maybe will work something out with you. He went and talked to Miss Aura, and the deal that she told you about was a deal he was trying to work out with her, but nothing ever came of it. So instead of coming back to us with something and trying to make it work, he went and tried to do eminent domain or whatever it was and say that her land had grew up and she wasn't taking care of her land, so he could find a way around it and just take the property. And that didn't work, so we came back to him, and he just basically said, in so many words, we'll just see what happens. Whatever happens, happens. And that's how we got to this point.
Okay. Are there any questions for Mr. Finch?
You asked for who?
Sorry, we're just looking at some stuff.
I don't know if you necessarily for him, but I would be curious to know to see this incorrect survey.
I know some of that paper don't pertain to this, but.
Okay. All right, if you want to come back up, Mr. Applicant, do you have anything to say about that?
So the structure is within the boundary lines. It is we got it surveyed twice. The actual structure of the building is within those boundaries. The tree situation, I'm not too aware of this tree situation. I used to own this lot, and I sold it to the applicant. I'm a builder myself. I sold it to the applicant. They built it, and this is where they ran into this issue. So when they're saying like, hey, we spoke to you 2 years ago, like, we're not involved. We sold it to the applicant. You can check the deed. A couple months ago, it was sold to Ace Capital, which is the applicant, Carlos Sanchez. Those are the individuals that built the house. And the house is within the boundaries. The tree situation, from what they have told me, they have drone footage and they have photos of where the property lines are, like where it's staked, and you can see that it's like half the tree is on the stake. So when they were clearing the lot, they just cut the grass, they cut any trees that were on their property, and that tree was also cut as well.
Okay.
Is there any questions?
Any questions for the?
You mentioned well, the staff report mentioned a incorrect survey. Can you tell us a little bit about that? And
Yeah, I think
what company?
when I was reading the staff report, it wasn't that. It was an incorrect survey. It was the site plan was marking that we had more space than what we had, and then when they went to build it, they built it too close on that setback. So you'll see on the site plan, it wasn't. Then they got another survey, and that's after, the survey that they got was after, they got two surveys. One was a boundary survey, and the next survey was once the building was already built. So that was the original site plan. And then after the situation happened, they had to go back with the architect, request a new site plan for the variance.
Just look at a couple things real quick.
There you go.
So that survey was done post foundation.
Correct, but there was a boundary survey that was done, but difference between this survey and the digital surveys, they usually just go out there, stake the corners, and then afterwards you pay more, and then you get that survey, which is the digital survey. So they had the corners staked first. Once this situation happened with the inspector was like, hey, you know what, you don't have enough, the setback, the rear setback is not, the side setback isn't the 5 feet. Go get a survey. We got the survey, and that's the survey right there.
Where was the inspector, what was he using to figure out where the corners were? Were there stakes?
They're stakes. They're stakes.
So the guys that did it should have known they were less than 5 feet from those stakes when they did the foundation.
Yeah, that's the problem. So I guess on the right-hand side, when the concrete guy was forming it up, he noticed that it was sloping a little bit too much, so he just moved it a little bit, thinking.
Sounds like a lawsuit against a concrete guy. I mean, that's crazy. I mean, you should be getting like a form foundation, and then like having that surveyed to know that where you put the forms, even in the right place, so you don't run into this stuff.
That's kind of what I was saying.
That's typically standard. It used to be standard practice. That like if you're, is there a loan on it?
Yeah.
And they didn't get a form survey?
No. It's
I mean,
he just got his builder's license last year. We're helping him out.
Yeah, well,
and he's just
he may just be learning a lesson is what he might be doing.
So it just took a lot of leeway to shift over.
I mean,
he's built, I think around, let me see, I think 15 houses since last year, and this is the first time this has happened. He's building a lot of 4 to 5 bedroom homes to cater to Memphis Housing Authority, a lot of those MIFA tenants, and a lot of people are complaining because there's not enough 4 to 5 bedroom houses in Memphis to cater for those families. So that's basically what he's specializing in. trying to use as much space as possible. That's why the house is that wide, because it's a big house. It's 1,800 square feet, 5 bedrooms, 2 bath. But it's the first time that you can check his building's license. It's the first time that's ever happened. It's just a mistake that wouldn't happen again. Lesson learned to get the survey again once the forms are done.
Yeah. Okay, any other questions for the applicant? Okay, hearing none, if we can get a motion to approve BOA 2026-41.
So moved.
Second. All right, any thoughts? A little bit of a mess.
If this was any other case, and it was this type of encroachment on the easement, on a setback, it'll just kind of be like, okay, this one just feels like just gross negligence of encroaching it. Nevertheless, to the plaintiff's concern, just kind of giving her a little, moment of clarity, she will still, this shouldn't affect her thought process of having space between both houses. Because even if they went with a 2.5 foot setback as opposed to 5, jointly that's a 5 feet to lawnmower or whatever the issue was. So devil's advocate, I hate the fact that they just kind of did it. I'm torn on what you do at this point.
So you're saying that she's not forbidden from building whatever she needs to build on her line? With the proper setback?
Yeah, because this is not encroaching the property line. It's just encroaching the setback. So let's just say she did honor her setback of 5 feet. Well, that still gives you 7.5 feet for maintenance. And even if she encroached her setback and did 2.5 feet, similar to what he did, you still have a 5 foot clearance to. It's not like you got 2 feet between houses to move.
If you put up a fence, that's where you run into issues.
So if the fence was right on the property line, well, it still wouldn't affect.
No, it would just, you're right, it would affect him. It would affect him.
He just made it tighter from his side if a fence was to go there. Because that only leaves 2.5 foot between. But her side technically does not get affected.
Unless she tries zero it out.
I mean, honestly, there's no effect to hers except the fact that it's a little close. It's 2 foot closer than you would want it to be.
And it would have to be fire rated.
What's injurious to the neighborhood is that this is Ace Capital Homes, plural. He does this for a living. And so you don't scoop concrete. When you form up concrete down the line and you inspect it, you see exactly where you're pouring it. And from what we've heard, the issue was present at the time of pouring the concrete and pouring the foundation. So what's injurious is letting someone's business model go through neighborhoods without accountability. I do concrete for a living. We can't scoop concrete.
Okay. Do we need to put anything, just if it was to get approved, do we need to put anything regarding the fire rating in there, or was that be taken care of by the building inspector?
Correct, it would be taken care of by the building inspector and code.
Okay. Other thoughts?
Should we make him put a fence up as a condition?
Doesn't look like there are other fences in the neighborhood.
Yeah, and I'm just thinking about her privacy as they encroached.
Well, my only question to that is, would 2.5 foot difference be what constitutes having a fence and not a fence?
I'm just trying to decide on how hard of a lesson we're handing down here.
I don't know, maybe put a fence up and do it before they keep going. I mean, they're walking all over her property and all this stuff, and they've clearly shown they don't care about the boundary.
Yeah, I mean, those pictures, some of them, they tore it all up.
Yeah. I think we can. I don't know how easy it is to do the rest of the house with only 2.5 feet there.
Yeah, it's easier for them having to tear it down.
Yeah.
So if we had them put a fence up, would they have to put it up before they finished working on the house? I mean, could we require that?
I think we can.
Because we just say put a fence
Yeah,
up.
it would be
they'll
up
finish
to
the house
y'all.
and then the fence last.
No, we could require it now.
And are we requiring the fence to go all the way to the sidewalk?
No.
No, I would do
Okay,
it to the,
just to the house?
Just to whatever the normal,
Yeah,
6-foot fence would be allowed. It could go to the edge of the porch. Okay. So y'all would be willing to add a condition for like a 6-foot wooden fence added to the south side of the property on the property line prior to continuing construction.
we dictate privacy fence.
Yeah, a 6-foot privacy fence
Privacy
or
wooden
such
fence.
other fence as approved by the zoning administrator.
I think site proof, right? Is what we want
Site
approved by privacy. Okay, so we'll just
Well, I
say
don't
site
like wooden
proof.
fence, and then they put a fence panel every, 4 inches.
Yeah, what would you call that?
You said what kind of fence?
I guess site proof, is that what a?
Yeah, site proof fence.
I don't know how to describe it, a wooden fence that goes in somebody's backyard. That
Yeah, not a picket fence.
Yeah.
What
Yeah,
our,
site-
what our
site
friends
proof.
from early needed.
Yeah, exactly. Yeah, so a 6-foot wooden site-proof fence.
That'll work.
Okay.
Then I guess, would it go to the front facade or like, I don't know what to call the porch part?
I think it would go to the porch.
So like the front of the porch?
No, to the front facade in the porch. So where the windows are on the. Yeah, just code.
Makes sense. Okay. To the front door? Yeah, maybe we'll say to the front door, because the front facade is technically like.
Right.
So maybe we say to like the front
door. Okay.
Parallel with the front door.
There you go. Okay. All right, so with no objection, we're gonna add that. Any other thoughts?
I do have one, Mr. Chairman.
Yes, sir.
And we're trying to require that the fence be erected immediately?
Prior to continuing construction.
Okay. One of the things I think about, I mean, they still, if this is reflective of where the building is today, would that be enough room for them to install fascia board and finish work?
They'll have to. Yeah.
Because think about it, if she was already there and had a fence properly along her site, her property line, they would have plenty
Microphone?
Oh, I was just simply saying, if she was there first and had a privacy fence or, a fence in that same site, they would have to deal with those factors while constructing. And maybe that's why the 5 foot makes sense. So you can do these things. So
What's the, I guess, the benefit of doing it, erecting a fence today? Is it just to protect her property while they're under construction?
To keep them off the property.
There's been a blatant disregard for her property so far, so it might need to be enforced. Other thoughts? Okay, Mr. Pensis, you give us a roll call, please.
Mr. Love?
So we're voting in affirmative
Yes,
with the
as
condition.
amended.
Yes.
Ms. Conrad?
Yes.
Mr. Claybrook?
Yes.
Mr. Campbell?
yes.
Mr. Bruce?
Yes.
Ms. Skurlock?
No.
Vice Chair Savage Selden?
No.
And
I-
Chair